And thank you very much for joining us here on PM Express. On the show tonight, criminalizing non-disclosure of assets. And we're looking at the case of the Conduct of Public Officers Bill. And this is a fascinating piece of legislation that the Attorney General went to Parliament yesterday to introduce, read for the second time. It has some very interesting provisions in there that we need to go through because it's another of the pillars in fighting corruption. But what does it do? Do we need another legislation in this particular agenda in winning the war against corruption? Let's go through what we know so far as this particular bill is concerned. It was first laid in the Parliament in 2018. Now, when passed into law, it will help regulate how public officers conduct themselves, but specifically dealing with some of the specific areas in terms of their conduct. The prospective public officials must go through before, during, and after holding a public position. And it also includes, for instance, punishments for a regime for public officials who abuse their office to exploit others or cause financial loss to the state. Now, this Attorney General has been arguing will boost the fight against corruption in the country. Now, they also believe that it improves Ghana's legislation to meet the United Nations and African Union minimum standard. There are some provisions that we've signed on to internationally that we want to bring this into conformity with. There is the asset declaration regime that this also touches on. Particularly of interest is the aspect of this particular legislation that Parliament is considering, which will criminalize the non-declaration of assets, which is a key point, right? But also a provision in there that says that once you've declared your assets, any assets that you acquire after you've declared your assets is deemed to have been acquired illegally, unless you can justify it. But there's a controversy. The biggest concern that anti-corruption campaigners have had when it comes to the asset declaration regime, for example, is that you can declare your assets, but it is confidential. And so it's sealed in an envelope and nobody knows what's in there. This particular bill before Parliament still makes it confidential. And, the concerns have been raised, so what's the point? Although it imposes a prison term for failure to disclose the assets or disclosing false information, it still makes it confidential. The Auditor General can look at it, but nobody else can have access to it unless the Commission can and all other, legitimate state institutions. There's a lot to go through this for you. Stay with me. When we return, my guest, of course, will join me as we begin to pour through this. Joining me right now on the program tonight is Ben Abdallah, who is a chairman of the Constitutional Legal Affairs Committee in Parliament. Also joining me is his ranking on that same committee, Mr. Inusa Fuseni. I'm also joined by anti-corruption campaigner, Mr. Vitus Azeem, who, of course, used to be the head of the Ghana Integrity Initiative. Mr. Inusa Fuseni, let me start with you because I've heard you yesterday on the floor vehemently, of course, defending this particular piece of legislation before your House for consideration. But let's start with the asset declaration bit of this. And I've heard concerns raised that this particular bill as it stands wouldn't do much to fix the challenge with the asset declaration as has been designed to help deal with corruption, because the deterrent there of publishing this, the assets once declared, is still missing. In fact, it is still pretty confidential in the bill as it stands currently. I wonder what your take is on that particular aspect of this bill. What is it coming to cure if it still doesn't allow the assets once declared to be accessed by all of us?
Well, let me say good morning, good evening to your distinguished co-panelists and also to your viewers, and to say that, yes, this bill might not be a perfect bill, it might not meet the expectations of civil society organizations who had wanted provisions inserted in the bill which could make the publication of the assets of public officers mandatory. But this bill goes a long way in improving upon the legal regime that we have presently. It will also prescribe deterrent sentences for persons who violate the provisions of the bill. And so, yes, it's a step in the right direction. It's one of the sunshine legislations that we have passed. It's also in fulfillment of our obligations under the UN Convention Against Corruption and also the African Charter on Corruption and Prevention of Corruption. And so, yes, I believe that if the bill sees the light of the day, we will see some remarkable improvement in the asset declaration regime. Persons who hitherto were not deterred by the sentencing regime under the existing law will now know that if they fail to comply with the express provisions of the bill, they will be had done by the bill. And so, yes, I think that that is what I can say for now.
Mr. Ben Abdallah. Mr. Abdallah, so Mr. Minister Hussein is talking about the sanctions regime that this particular bill now introduces for failure to declare your assets or if you declare falsely. I mean, but I want you to address the question about the confidentiality attached to this still. What explanations, I wonder if at all, has the Attorney General given for why we're still making the assets once declared confidential? Because that could be a huge deterrent.
Good evening, Joynews. Let me say good evening to all my co-panelists. The confidentiality of the declaration is based on the premise that the declaration made is the declarant's or the public officer's personal information. You know, to a large extent, under our legal regime, personal information is exempt. But if you read the language of the bill well, the language of the bill seeks to be saying that unlike the existing enactment that deals with declaration of assets, if the Auditor General has the responsibility to be periodically publishing public officers who are supposed to declare their assets, public officers who have declared their assets, and public officers who have not declared their assets. And I believe this provision that is yet to be approved by Parliament is an improvement on the existing legislation. And quite apart from that, we all do know that not long ago, Parliament enacted the Right to Information Act. With the coming into force of the Right to Information Act, if anybody suspects or alleges that a provision of the Constitution dealing with declaration of assets or a provision, a provision of the Asset Declaration Act has been contravened, the Right to Information Act gives the person the right to report to the appropriate authority for the necessary action to be taken. Yes, I would say, yes, it is true that once you declare, that declaration ought to be kept confidential, but it is not as confidential as, it will not be as confidential as it is in the current regime when there's bill, Conduct of Public Officers Bill 2018, later on sees the light of day. Let me say this by emphasizing the fact or stating the fact that the provisions in the Conduct of the Public Officers Bill are not final provisions. Let me say these are proposed provisions or bill coming from the Office of the Attorney General, which was brought to Parliament and referred to the Committee on Constitutional and Legal. We have also proffered certain amendments, but the amendments that we have proffered are subject to the final approval of Parliament. So don't be surprised if at the end of the day, certain provisions in the bill do not find the light of day, or do not see the light of day, or at the end of the day, if those provisions are not approved by the plenary.
Mr. Nusaf, in which specific aspects does this particular bill improve the asset declaration regime? Kindly unmute the Zoom for me. I think it is muted.
Okay, I've done that.
Yes, I can hear you now. Yes, I was asking.
First of all, the bill seeks to give the Auditor General the authority or power to inspect the declaration of a public officer at the point of declaration and to issue queries on verification, on clarification of assets declared by a declarant if, in the view of the Auditor General, the declaration is not complete or fails to meet the standard of proof that is required by the Auditor General. So yes, the regime can be thought of to be secretive if a person makes a declaration, but then even before the declaration is complete, the Auditor General has opportunity to look at the declarations and issue queries or questions or clarifications, requests for clarifications as the need may be. So now, the bill also makes it abundantly clear that where a person violates the express provisions of the bill or the law when it comes into operation, that person can otherwise be declared unfit to occupy public office. Now, in the current arrangement, we have seen of public officers violate not only the express terms of the Public Officers Act, but also the Constitution with careless abandon. I mean, they simply have failed to declare their assets within the time frame, and the Shiraj, the Commission on Human Rights and Administrative Justice, when it investigated those persons, came to the firm conclusion that they had been violations of the Constitution and the Public Officers Act, but could not exact the necessary punishments because the sanctions are not deterrent enough. And so this bill, when it passes the test of Parliament, will make the sentences of a person who violates the provisions of the bill very, very deterrent, very draconian, and so that a person could lose his job, or a person could lose salary, a person could be surcharged for salary received while in contravention of the provisions of the Act. I would believe that if the sanctions regime are tightened up, public officers will sit up and perform their duties according to the dictates of the law. The bill also seeks to ensure that the Commission for Human Rights and Administrative Justice will issue code of ethics for all public institutions to guide the conduct of public officers in those public institutions. So it extends beyond mere asset declaration or conflict of interest situations to include sexual harassment and imbibing intoxicating substances while on official duties. They are all deemed to be corrupting activities. So yes, the bill extends beyond that. Yesterday, I was asked whether using office time to watch TV or to work lotto will not be caught by the bill. And I said, look, because the Commission for Human Rights and Administrative Justice has responsibility to issue a code of ethics for the conduct of public officers in their various public offices, the code of ethics might provide for sanctions for officers who will use their time wastefully in doing things that are not sanctioned by the conduct of public officers in their various offices. So, yes.
There's a clause in there that I find pretty curious. I want to bring in Mr. Abdallah on this. This is still on the asset declaration. The clause 6 talks about the fact that once you've declared your assets, any assets that you acquire post the declaration will be considered to have been acquired unlawfully unless they can reasonably be regarded as income, acceptable gift, loans, inheritance, or otherwise lawful. That sounds to me like a pretty harsh provision. That so what between once I come into the office and I declare at the beginning, I cannot acquire any more assets. I mean, once I do, automatically it has been considered by the law to have been acquired illegally and unlawfully. Isn't there such an unrealistic, pretty harsh provision in the clause in the bill? Okay,
let me say that this is not a new provision. In fact, if you go to Article 286 subclause 4 of the Constitution, that is the language that has been lifted from there and inserted in the law. It is not automatic. What it is seeking to say or do is that if after the declaration you subsequently acquire some property and you are unable to explain as to the legitimate source of the acquisition of the property, this provision is saying that then the properties that you acquire subsequent upon your declaration need to have been unlawfully acquired. So it is subject.
I'm on the Zoom. I can talk on the Zoom.
So it is subject to.
The Zoom is fine. I can speak on the Zoom.
Able to clarify and explain as to the legitimate source of the acquisition of those properties. Now, the Auditor General, unlike in the existing Act, is again given the power or the mandate to seek for clarification if the auditor, within a certain period of time, I mean, the Auditor General will give you a written notification calling upon you to come within a certain specified time and explain maybe certain issues which are ambiguous, or to appear before him to explain as to the legitimate source or otherwise of the acquisition of any properties you acquired consequent upon the declaration of your assets. So it's not anything draconian, it's not anything new. In fact, it is intended to ensure that people who have declared their assets will not subsequently unlawfully acquire assets and say that they acquired those assets lawfully. It is intended to check and to minimize, if not prevent, corruption completely.
Ms. Abdallah, you make an important point. So this is already in the Constitution, as you've said. It's been inserted in this new one. But you can correct me if I'm wrong. People in power and in public office definitely acquire property in the course of being in office. I'm yet to hear of a case where this provision in the Constitution has been enforced. If it hasn't been enforced and it's already there, but we are lifting it now and putting it in another legislation, repeating it, you know, just for the sake of it, it's a waste of space. We should simply enforce what is in the Constitution. If we can't enforce what's in the Constitution, what's the guarantee that this will be enforced?
You see, the Constitution just gives a bare provision. Puts the language there without giving any details. That explains why anytime the Constitution provides a provision of this nature, it is always advisable to enact a legislation or an enactment describing in detail what the Constitution is saying, taking into consideration the spirit and the philosophy behind that provision. So now, the Constitution has just put it out there, but this enactment or this bill is making it an obligation upon the Auditor General to be periodically checking if, after the declaration of an asset by a public officer, subsequent acquisitions of property have been made. If subsequent acquisitions of property have been made, then it behoves on the Auditor General to invite that public officer to come and explain as to how the public officer came by those properties. That explains why the Constitution is saying, and this bill, when it becomes a law, is also complementing the provision of the Constitution by putting an obligation on the Auditor General to call upon the public officer to come and give further and better particulars, failing which then those properties will be deemed to have been unlawfully acquired, and the necessary legal processes will then be activated. So it is not a mere provision.
Okay.
It is a provision which is being incorporated with flesh and with a very comprehensive sanction regime.
Okay, I want to bring in Vitus Azeem, anti-corruption campaign. Mr. Azeem, what's your reaction to all this particular aspect of the conduct of public officers bill relating to the asset declaration regime?
There is clearly no difference between this bill and the Act 950 or so. We had a meeting with these people in 2008 in Ho, and I think Alhaji Yusuf Hussein was there. The same issues that we raised are the same issues that they are raising today. It is called a public asset disclosure regime. What is disclosure if you declare your assets in an enclosed envelope and the Auditor General just issues you a receipt saying that we have received your asset declaration and it's not open, nobody can see it? If my MP claims that he has a house in my village, and I'm not aware that that's what he has put in his asset declaration for, how can I challenge him? So it is not any serious law as far as that aspect is concerned. If they keep it like that, we are just wasting more time that we wasted on the asset declaration, which was law which was passed as far back as 1998. Then there are other issues. One, they said that before, the Constitution says upon assumption of duty. This bill says before taking office, but then goes ahead to say that within 30 days, not later than 30 days upon assumption of duty. 30 days is a very long time for somebody to acquire assets. You can buy 2 cars within 30 days. You can get gifts of 2 cars within 30 days. Why doesn't it go with the day that you are being sworn in? Why don't you bring your declaration on the day that you are swearing, you are being sworn in? Why that thing? The confidentiality is a very serious matter. There was another issue that we raised in that 208 meeting in Ho, as spouses and children below 18. The parliamentarians said, no way, they are not public servants, they wouldn't put their names there. If we bring the regulations before Parliament, they will not pass it. And it's the same thing that is contained in this thing. So we are not making progress. I don't think we're making progress with this thing as an anti-corruption tool.
Thankfully, we've just been joined by Deputy Attorney General Joseph Kpenka-Diop. Mr. Kpenka-Diop, thank you for your time here on PMXS. What's your reaction to Vitus Azeem there? It doesn't see much progress with this particular piece of legislation as it relates to the asset declaration regime. Please unmute the Zoom for me because we can hear you. Okay. Can you hear me? Mr. Diop, can you hear me? Okay, let's...
Another thing, whilst you are struggling with that. The other thing is that the bill provides for 2 regulations, 2 sets of regulations, one by Commission for Human Rights.
Hi, Mr. Azeem, give me a second. I think I can hear him now. Mr. Kpenka-Diop, yes?
I can hear.
Yes, give it a try. Let's see. I mean, hopefully we could have a clearer connection to you. Yes, you were saying, you're making a point. You're reacting to that position that we just had expressed there by Ms. Azeem. Okay, I think the connection there isn't great. Ms. Azeem, you were making a point.
Yes, I was making a point that the bill provides for 2 sets of regulations, one by the Commission for Human Rights and Administrative Justice and one by the Auditor General. The 1998 law, asset declaration law, still doesn't have regulations. So these regulations that they are making provision for can take another 4 years. We are just close to an election. And if they don't present those regulations before the Parliament, before we have elections, then it's going to be another long story. So these are some of the issues that we have with this bill that if passed by Parliament, and even from the way the parliamentarians are talking, there's no guarantee that it's going to be passed. But if passed by Parliament, it will still be the same as the old Asset Declaration Act that we had.
Is Mr. Kpenka-Diop back? Okay, let me bring in Mr. Musa Fuseni. Mr. Fuseni, how do you respond to the concern there that there's a bunch of politicians club in Parliament passing very safe legislation to protect yourselves? I get the sense from what Vitus Azeem is saying that this has been tossed back and forth for a while. It's come back in the form of a public conduct of public officers bill, but it's really not much progress.
Well, Vitus Azeem has every reason to believe that we have not made much progress. 2 weeks or 3 weeks ago, I was in Kofedwa to consider this bill with my chairman and a committee of experts. We also had reasons to believe that this time it was not only the politicians who were struggling to whittle down the effect of the bill, but public officers and experts. And so we need to show enough commitment to be able to deal with the canker of corruption in our public life. And so for me, the good thing about the discussion is that we are discussing the contents of a bill, not a law. And when the bill finally goes through all the stages of Parliament, it might come out in a form that will meet the reasonable and legitimate expectations of Vitus Azeem. And so don't let us throw away the baby with the bathwater.
I guess maybe I should ask you, let me ask you a direct question. Let me ask a direct question. As a politician yourself, a public servant for many years, would you support an inclusion of a provision that makes the assets once declared public?
I will support a provision that makes it possible for persons who have reasons to believe that I have not declared all my assets, or I am acquiring assets outside the assets that I've declared, have access to the declaration that I've made without necessarily going to court, without necessarily stirring a controversy, and without necessarily appearing before a human rights and administration, a commission of inquiry appointed under the Constitution. It should be possible that persons like Vitus Azeem and his type, who are in civil society organizations, non-governmental organizations, and who have been championing the fight against corruption, to have access to the declaration of public officers even before any dispute or any challenge is made to them. That way, those public officers who are in public office will know that persons or people can have access to their declarations before even the court matter is started. And that way, it will put them on notice to do the proper thing. So for me, yes, I think that we can work on the bill and ensure that it meets our expectation. For instance, Vitus Azeem talks about 6 months, 3 months after taking office, or 30 days after taking office, you declare asset. The Constitution is very, very clear. Article 2861A says that 3 months before the coming into force of the Constitution. So the public officers, after coming into force of the Constitution, so public officers who were in public office, who were continued in office when the Constitution was promulgated, have 3 months to declare their assets. That provision is long been spent. It is no longer valid. It's spent because the Constitution came into force in 1992, and 3 months has since passed. So that provision has been spent. The next provision is before taking office. So now we are before taking office. So if a bill says 1 month after taking office, that provision will be inconsistent with the Constitution. It will be inconsistent with the Constitution because the Constitution gives the only two options. One, before the coming into force, after the coming into force of the Constitution, 3 months after the coming into force of the Constitution, which provision has been spent? It's a spent provision. It's no longer applicable. And then before taking office, as the case may be. So now that the Constitution has been in existence for more than 25 years, that provision doesn't apply. It's gone. So we now have to make a law that makes it mandatory for public officers to declare their assets before taking office.
Okay.
Now, my chairman spoke about the provision in the asset declaration bill that requires a person to show just cause, to show cause why his assets should not be treated as assets illegally acquired by reason of the fact that they were not contained in his original declaration. That is how we fight corruption. If we look at the FATF rules, Financial Action Task Force rules, the burden shifts onto a person who has not declared his assets, or who has not declared assets, or who have acquired assets after declaring his assets, to show how he acquired those assets. And if he fails to reasonably provide justification for the resources that were used in acquiring those assets, those assets were presumed to have been acquired illegally. So yes, to fight corruption, you need to shift the burden, and the burden is so shifted in this bill.
Yeah, let me. You served in John Mohammed's administration as Roads Minister, also as the Lands and Natural Resources. He has made a policy declaration on this subject when he adored Jane Opoku-Agyeman. He says, quote, it will be a requirement for all who serve in my government to publish their asset declarations and have it audited by the Auditor General. That's why I was asking you a direct question of whether you support it. That is your that is your candidate's position.
It in the sense that it should be possible. Publication means people having access to it, not putting it in papers.
Yes.
To make their assets available. That's what I've just said.
To the public.
Or to make their declaration forms available for auditing.
Not to the public.
People can have access to it for auditing purposes. That's the publication that His Excellency John Mahama is talking about, not putting it in papers.
Okay.
To make it available. And so for me, I support that. I even have advised that ministers of state who will be appointed by His Excellency John Mahama ought to show that they have complied with the asset declaration regime before they are given their instrument of office.
Let me bring in Joseph Penka Diop, who is the Deputy Attorney General. Hopefully joins us on the phone now. Mr. Diop, you were reacting to the Vitus Azeem position that we haven't seen much progress. This is a bill that your office has introduced and has altered. And so what's your defense, justification for the way it has been scripted now in this bill?
Yeah, thank you very much. Ivan, I would like to beg to differ very strongly from the position espoused by my brother Vitus Azeem in this matter. First of all, you've listened carefully to the chairman on constitutional, legal, and parliamentary affairs, and you've also listened to my elder brother, lawyer Inusa Husseini, very carefully. Now, let me state this. I will refer Mr. Vitus Azeem to the policy rationale, that is the memorandum accompanying the bill. If you read it carefully, then the position he is taking now will not be correct. Because the policy rationale or the memo accompanying the bill to Parliament is very clear that, one, first of all, we've ratified both the UN and the AU conventions in the last 15 years, since 2005. And in order to domesticate same, we've come up with this bill, the primary aim of which is to ensure that the lacuna, that is the gap created over the years by all the laws that we have in place to fight corruption, are filled by this particular bill. So if this bill passed into law, does not fill that lacuna created over time as a result of our practice of the various legislation that we have, then the purpose of it to that extent would have been defeated. But I can say without a shred of doubt that looking at even the committee's report that came, it was very clear. Then the memo, the committee's report, and the memo, and even the debate that we had in Parliament, it became very clear that this particular bill passed into law would take the fight against corruption to another level for all Ghanaians. And there's no dispute about that. He has some fears. But I think that with all respect to him, those fears will be addressed when the House debates the various clauses of the bill and arrives at that which is acceptable and that which will stand the test of time. Otherwise, if at the end of the day, both sides of the House, we pass that legislation which will not enhance what we have in place now, then the purpose of the bill itself, by the memorandum that came to Parliament, would have been completely defeated. And I don't think that that is what Parliament is going to do. Parliament is not a rubber stamp. It is a place where we're going to, posterity is going to judge Parliament for whatever we are going to pass as law. And so to go there and put in place a regime that will not be robust enough to complement what we have or take the fight against corruption to another level will be a waste of time to that honorable House. And I don't think that we'll engage in that gamble at all. So, first of all, look at all the anti-corruption provisions that we have. The one that all of us are talking about, basically, has to do with the asset declaration regime. Then, the exercise of discretionary power. and then public office holders and their conduct generally. These are the basic things that we need to look at and make sure that the various provisions are crafted in a manner as to address these concerns. So, for me, his concerns that he has raised are premature. We should wait, let us debate the issues, and let us come up with a final product. At that stage, that criticism he's talking about may or may not be relevant, but I think that it will not be relevant because the House is going to pass that bill into law that will stand the test of time. Again, as I stated at the beginning, if you look at the issue of asset declaration, as we have all indicated, clearly a bit of it has a problem. And all of us know as Ghanaians that a bit of it has a problem. And so this is going to be crafted in a manner to address that problem, which is a concern to all well-meaning Ghanaians. One, if you look at the current state, you make the declaration, seal it in an envelope, you drop it at the Office of Auditor General. And in most cases, unless a disputation arises, and Sheriff will have to go in to do investigation to authenticate or otherwise, then it remains as it is. After you've left office, then there are no concrete laid down procedures for verification to authenticate and find out whether or not acquisitions were made subsequent to whatever you have declared. So if we are drafting this legislation, what I expect basically, which we are going to do, is that we'll address that bit, which will allay the fears of the public to the extent that the public thinks that what it is now is not transparent enough. But there are penal consequences if you conceal or you fail to declare. There are penal consequences, constitutional penal consequences, far-reaching enough, including but not limited to the fact that you could even be debarred from holding public office if you fail to declare your assets. So there are penal consequences. All we need to do is to make sure that it enacted in a manner as to criminalize this very clearly in certain provisions of this act, so that anytime any person sins against it, we can pick it and say, this is it, and we proceed to court to exact criminal sanctions against any person who may have flouted sin. But as I said, I think that this particular bill, if you read the memo carefully, you read the report of the committee and the various clauses of the bill, if debated and passed, indeed, it cannot be the case that what we used to have will be the same thing. In fact, it will be a complete departure and an enhancement over what we have in the present regime. Okay,
I mean, I would quickly take a break. When I return, I'll get Mr. Azeem to give me his thoughts on the assurances that he's just heard from the Deputy Attorney General. But this bill is not only limited to these key aspects we've talked about already. There are provisions that regulate generally the life of a public officer, including alcohol consumption, sexual harassment, etc. The key question that it all boils down to is enforcement. There are plenty of these regulations scattered across legislations. The problem has always been enforcement. What will make this different in terms of enforcement? Stay with me. My guest, Joseph Penkadioh, is the Deputy Attorney General. Vitus Azeem is anti-corruption campaigner. Ben Abdallah is the chairman of the Constitutional Legal Affairs Committee in Parliament, and Yusuf Hussaini is the ranking on that same committee. Mr. Vitus Azeem, you heard the Deputy Attorney General just before the break explain and make assurances that, of course, this is going to be enhanced as the debate ensues. Does that address your concerns you have, and how much faith do you have in the process going forward, that by the time we get to the end product is better than what it is currently?
Is to help make contributions to the debate by Parliament. So my aim is not just to destroy the paper, the bill, but to point out the issues that I have with the bill. And so I'm happy that it appears some of them have agreed with some of the issues that I've raised. But there's just one more issue I want to raise.
Okay.
We were fighting that any public officer who has custody of or in control of public resources, public property, should be included, even if you're a junior officer, not to the level of director. So if you're a storekeeper, if you control the fuel station at the presidency, you should be subject to this asset declaration law. Number two, there are politicians, special assistants and all that who are being paid higher than directors in the civil service. They should and have control over what their ministers do. So they should also be included in the bill. Finally, the asset declaration bill was passed when the military was handing over to the civilian regime. And so the armed forces were exempted. It is an old provision. I don't know why it's carried forward again to this bill. After 25 years of going to democracy, the armed force is the only institution that is left out of this asset declaration. I don't understand.
Let me bring in Mr. Ben Abdallah. Mr. Abdallah, let's quickly talk about enforcement here. I mean, one of the biggest challenges we have as a people is that anti-corruption legislation is scattered all over the place. This obviously is one additional one. But enforcement has always lacked. I mean, as a chair going forward, what is it about this that makes this different or could make this different?
Okay. Let me first of all say that the door of Parliament is not closed. As I said in my preambular statement, that whatever is captured in the bill is a mere proposal. So my senior brother, Vitus Azeem, if he has any proposals as he's bringing them out now, can put them into writing and let the clerk of the committee have it before we begin the consideration of the bill. And let me also say that the issue of the confidentiality of the asset declaration regime is grounded under Article 18.1 of the Constitution. Under Article 18.1 of the Constitution, it says that every person has the right to own property. And 18.2 says that no person shall be subjected to interference with the privacy of his property unless for public safety or for the prevention of disorder or crime. So if your assets is being held under the confidentiality regime and anybody alleges that for public safety, public interest, for the prevention of crime, for non-compliance with the provision of the Constitution on the asset declaration regime, that secrecy ought to be taken away. The law is of the view that that confidentiality will be. But coming to
the quick, we just don't have time on this, but if you could quickly give me the point on the enforcement.
Your question.
Yes.
I believe that the Constitution under Article 287 makes it abundantly clear. And if you read 284, dealing with conduct of public officers, as well as dealing with declaration of assets, it sets out clearly that for the avoidance of doubt, clarity, let me read 28716. An allegation that a public officer has contravened or has not complied with the provision of this chapter shall be made to the Commissioner for Human Rights and Administrative Justice. And in the case of the Commissioner of Human Rights and Administrative Justice, to the Chief Justice, who shall, unless the person concerned makes a written admission of the contravention or non-compliance, cause the matter to be investigated. So what this Constitution is saying is to the effect that if anybody alleges that a provision of this article, right from Article 284, 285, 286, coming downward has been contravened, then a petition ought to be submitted
to Shraj to deal with it. I'm grateful, Chairman. I'm grateful, gentlemen. We'll return to this as it progresses through Parliament. Enjoy the rest of your evening.